Let me begin by expressing my thanks to the Vandenberg Society for organizing this timely discussion of the promise and perils of human rights, and for giving me the opportunity to say a few words about the recently released report of the United States Commission on Human Rights. When US Secretary of State Michael Pompeo created that commission last year, it was with one very generally expressed aim. It was to assist the State Department by refreshing the understanding of the principles that underlie the commitment of the United States to promoting human rights in foreign policy. Beyond that, he gave the Commission only two rather cryptic instructions. The first was that we were to operate at the level of principle, not policy making. And the second was that we were to ground our work in the distinctive rights tradition of the United States and also in the international principles to which the United States is committed. And specifically, our charter mentions the Universal Declaration of Human Rights. Now, as you may be aware, the creation of the Commission last summer was somewhat controversial. It was greeted with a good deal of surprise. No previous Secretary of State had ever done such a thing, and some people wondered, why do we need that kind of a commission? What's the point of a study that doesn't deal with the burning issues of the day? And doesn't the State Department already have plenty of people who are working with human rights? And those are reasonable questions. And I suggest the germ of the answer can be found in something that Henry Kissinger once said when he was reflecting on his life as a professor compared to his period of service as US Secretary of State. He said, when I was a professor, I could choose whatever subjects I wanted to work on. I could take as much time as I needed, but a policymaker is always under pressure. Policymaker has to make decisions by a certain date, often on woefully inadequate information. And the risk for the policymaker, said Kissinger, is that the urgent will often drive out the important. Now, Secretary of State Pompeo took a certain step toward alleviating that risk by commissioning a study that would go back to basics, that would begin with the principles underlying this country's international human rights commitments. But it seems to me there's a much deeper significance to the decision, and one that has not been much noticed. Most people take for granted that foreign policy is mainly a matter of power and interest, and power and interest certainly do figure importantly. But here was a US Secretary of State showing an extraordinary interest in the role of principle in US foreign policy. And never before had a US Secretary of State ever said anything like he wanted to help strengthen the intellectual defense of the great post-World War II human rights project, as Secretary Pompeo has done in speaking about the Commission's report. Still, some people asked, why now? Why have such a study just at a time when there are so many other matters pressing for attention? So let me suggest just a few reasons why this is the right moment for this kind of study. I'm sure you can think of others. One that figured prominently, I would say even most prominently in the minds of the commissioners, is the simple fact that over 1/2 of the world's population, 4 billion people, are presently living under authoritarian or quasi-authoritarian regimes where they are denied the most basic freedoms that we in liberal democracies take for granted. It was sobering to read last year in Freedom House's survey of 195 countries that political and civil liberties worldwide are presently in decline for the 14th consecutive year. Add to this what Human Rights Watch reported last year, that some of the world's most powerful countries are not only ignoring basic human freedoms, but are making deliberate efforts to undermine the fragile consensus that supports the international human rights system. In other words, they are openly challenging the ideas that transformed the moral landscape of international relations in the late 20th century. The idea that no nation should be immune from outside scrutiny of how it treats its own citizens, and the idea that certain fundamental rights belong to every single human being simply by virtue of being human. China, in particular, has been promoting an alternate conception of human rights in which various national goals prevail over the basic rights to speech, assembly, the free exercise of religion, and free elections. Among other threats to human rights, new threats, ominous threats are coming from the area of new technologies, biotechnology, artificial intelligence, data collection, sophisticated surveillance techniques, all of which hold promise, all of which contain perils. And add to this that time has taken its toll on the understanding of the human rights that grew out of the ashes of World War II. The understandings that played such a key role in the demise of apartheid in South Africa, the toppling of totalitarian regimes in Eastern Europe, so that you could say today human rights are misunderstood by many, manipulated by some, and ignored by the world's worst human rights violators. In sum, matters have reached the point where the former Secretary General of Amnesty International used the word deadlock to describe the current state of the human rights system. And he said, now is a moment when we should step back. Friends of human rights should ask fundamental questions like, why do we have human rights? What are they really for? And that is exactly what Secretary Pompeo commissioned a group of experts to do. I could go on with all of these reasons, but the point I want to emphasize most is that multitudes of men and women around the world, men and women who are suffering persecution, torture, arbitrary imprisonment, even as we speak, the fact that these men and women are looking to the United States and to other liberal democracies for hope, help, and encouragement is what led our commission to its principal conclusion, namely that the United States ought to rise to today's challenges with the same energy and spirit that it brought to the Human Rights Project in the years right after World War II. Now, let me digress for a minute here to say something about the commission. It's important to know that it was constituted under a federal statute as an independent and nonpartisan commission. And that's an obligation that all of the commissioners took very seriously. We are of different political affiliations, different races, religions, and ethnic backgrounds. There were human rights activists among us, human rights specialists among us, specialists in international and comparative law. And like other Americans, we were not of one mind on many of the great issues that divide our society today. But every single commissioner shared two convictions. First, that fundamental human rights belong to everyone, everywhere. And second, that it is critically important for United States and other liberal democracies to vigorously promote human rights in their foreign policy. It was one of the hopes of the commissioners that in the course of our work, we could help to clear up some of the misunderstandings about international human rights that have taken root over the years. And those sections of our report, I have to say, are necessarily nuanced because, if I may call on Aristotle here, because in the realm of human affairs, it is impossible to speak with the exactness of the natural sciences. One has to speak partially and for the most part. So to take one example, a very fertile source of confusion has been the common habit of reading the Universal Declaration of Human Rights the way Americans read their Bill of Rights, as a list and not as an integrated document containing a set of interrelated principles along with its own internal guides to how those principles are to be interpreted. And that practice, treating the UDHR as a kind of a la carte menu, has given rise to much controversy about such matters as how much leeway does a nation have in deciding which rights to prioritize? Or what is the scope? What are the limits of rights when one right, as so often happens, clashes with or is in tension with another? And third, how to assess new claims or new interpretations of fundamental rights. Those are three of what we in our report called the hard questions about human rights. And since they are likely to figure in your discussions of the promise and perils of human rights, I'd like to say a few words about how the Commission approached them. Regarding the scope and limits of a legitimate diversity in bringing human rights to life in a particular national context, the Commission's took its bearing mainly from the UDHR itself and from the 1993 Declaration of Human Rights, the Vienna Declaration. The question is not an easy one, as is evident from the Vienna Declaration, which tells us on the one hand, quote, "It is the duty of states, regardless of their political, economic, and cultural systems, to promote and protect all human rights and fundamental freedoms." But then it goes on to say immediately that, quote, "The significance of national and regional particularities in various historical, cultural, and religious backgrounds must be borne in mind." So how does one put together the obligation to protect all human rights with the admonition to bear national particularities in mind? I know Europeans, from their experience with the margin of appreciation under the European Convention on Human Rights, know just how difficult that is. The Commission based its approach in part on the UDHR itself, which was deliberately designed to accommodate a broadly diverse set of political, economic, cultural, religious, and legal traditions. Indeed, it was only by allowing a limited degree of pluralism and meeting its standard that the Declaration was able to obtain approval from the already diverse United Nations membership in 1948. It was clear from the outset that the universality of the Declaration's principles did not mean uniformity in bringing them to life in various national settings, but neither did the Declaration's openness to a degree of pluralism mean that any claim of cultural specificity could be an excuse for violating or ignoring its principles. Rather, it represented the framers' recognition that broad general principles must be instantiated in specific and varying contexts. So where do we find those limits on what we in the report called legitimate pluralism? Well, the UDHR itself imposes certain constraints on the scope of diversity. Some rights, prohibition of torture, are so tightly drafted as to allow little scope for variation. That's reinforced by international law, which recognizes that some human rights are non-derogable, meaning that they cannot be subject to exceptions even in times of national emergency, while others are subject to many reasonable limitations or are contingent on available resources and regulatory arrangements. Some norms are recognized as jus cogens, principles that no state can legitimately set aside. Others allow for considerable variation in emphasis and modes of implementation, as is the case in the social and economic rights, which are prefaced in the UDHR by a chapeau article stating that they are dependent on the political organization and material resources of each state. Another constraint on pluralism comes from the inherent interdependence of the UDHR's principles, an interdependence which was made explicit in the Vienna Declaration, stating that all fundamental human rights are indivisible, interrelated, mutually conditioning, which means that they are meant to be interpreted in such a way as to work together, not to be pitted against each other. And that's plain from the often ignored parts of the Universal Declaration, specifying that everyone's rights must be exercised with due regard for the rights and freedoms of others, that rights are importantly dependent on the rule of law and on the existence of an order, national or international order, within which rights can be realized. That interdependence means that it would be a violation of a country's international obligations to wrench any of the UDHR's rights out of context, to ignore any part of the document, to focus exclusively on any part of the document, or to subordinate one right completely to another. For example, to completely sacrifice political and civil rights to social and economic rights, or vice versa. Cultural relativism can never be an excuse for violation of basic human rights. The Commission then went on to say in its report that it is no departure from all those affirmations to recognize that a nation's foreign policy can emphasize the principles that, that accord with national values, priorities, and interests at any given time, taking into consideration prudential judgments about current conditions, threats, and opportunities in the world around us. We commissioners thought that our report was clear on those points, but we learned later that many readers of the document thought that our treatment of the scope and limits of diversity was giving encouragement to notorious human rights violators who claim that national interest takes priority over human rights, which I can only take to mean that the concept of legitimate pluralism needs to be more widely discussed and better understood in gatherings like the ones in which you are participating in these days. Now, let me turn briefly to a related hard question of what should be done when basic rights clash or are in tension with one another. Take, for instance, the perennial tension between freedom and equality. Given the interdependence of the principles in the UDHR, it seemed to the Commission that conflicts or tensions should be approached as occasions to discern how to give each principle as much protection as possible, consistent with the overarching principle affirmed in Article 1 of the Declaration that all human beings are born free and equal in dignity and rights. That is, conflicts among rights should not be treated as contests where winner takes all, but rather as occasions for figuring out how to give maximum play to each, and in no case should one right be allowed to completely override another. The skill here, and it is a skill, I would say it's even an art, it is what the German jurists call praktische Konkordanz, which means the art of finding an accommodation that gives each right its proper scope. Like legitimate pluralism, that art is one that would greatly benefit from broader and fuller discussion. But now the next hard question, what if the clash or tension is not between established principles like freedom and equality, but involves new rights or a controversial interpretation of an internationally recognized right? Obviously, there can be no general formula for answering such questions, making such determinations, so the Commission confined itself to suggesting certain factors to be taken into consideration when assessing whether a new claim of human rights warrants support in US foreign policy. I'll briefly run through our list. First, how closely related is the claim to the language, how closely rooted is the claim in the language of the UDHR and other international human rights instruments that the US has approved or ratified? Now, in that connection, the Commission noted two particular cases where caution seems to be warranted. First, sometimes broad new rights have been championed by undemocratic and repressive regimes in an effort to undermine the effectiveness and the unity of internationally recognized rights. The second case is where activists in some countries want to bypass ordinary politics and ordinary democratic political processes at the domestic level and employ the language and structures of international human rights in order to advance agendas that are not widely shared in the community of nations, and sometimes not even within their own nation. Some other factors to include would be whether the new claim is consistent with American constitutional principles and traditions, not to say the perspectives of the United States should be decisive, but simply to recognize that an American policy that does not have the support of the American people risks losing domestic legitimacy. Another factor, have the United States and other like-minded democracies given their sovereign consent to the development in question through established political mechanisms for creating international law? Does the new claim represent a clear consensus across a broad plurality of different traditions and cultures in the human family, such as the Universal Declaration did in 1948? And finally, can the new right be integrated consistently into the existing framework of human rights? Again, let me emphasize that the Commission did not consider that these factors were exhaustive, nor that any one of them was definitive. Now, I'm bringing these remarks to a close, and I just want to say that the more the commissioners grappled with these difficult questions about human rights, the more we hoped that our report would stimulate further discussion among lovers of liberty about the principles and practices of freedom and about the political institutions that help to maintain a free society. So on behalf of myself and my colleagues, please accept our sincere thanks for your interest in our report and our best wishes as you ponder the promise and perils of human rights. Thank you.